last talk for today on day 2 of RT2. Here with us, we have Tim Vollmer, who is a scholarly, he's a scholarly communications and copyright librarian at UC Berkeley here. And he supports faculty, staff, and students with questions related to copyright, fair use, information policy, Creative Commons licensing, classroom workshops, and much more. Today, he will talk about why and how you should choose a license for your next digital project, especially as it relates to data sets. So Tim, thanks again for being here, and feel free to get started whenever you're ready.
Sounds great. Thanks, Alex, for the invite to present. So just kind of the usual disclaimer, I'm not a lawyer and this shouldn't be interpreted as legal advice, but I hope we can provide some good tips to you all in navigating some of these questions around copyright, contracts, and open licensing for today. The slides for the presentation I've uploaded to the repository for the Institute. So like Alex said, I'm coming from the library's Office of Scholarly Communication Services, and we work sort of across the university and also across the entire University of California to help scholars understand intellectual property, copyright, and other information policy issues that come up as they're doing research and publishing, and also for classroom instruction as well. So just a little bit of maybe locate ourselves here and sort of what's the overlap with some of the things that we work on. So in terms of the RT2 Road Map, I think there's several intersections with the work of our office and other sort of rights issues. So for example, we help scholars sort of understand their copyright and publishing rights, both in sharing pre-peer-reviewed versions of their scholarship on preprint servers. We also work with authors on open access publishing options, and we help guide them in complying with various open access policies, whether it's on their campus or other public or institutional open access policies. We've also worked with researchers on ethical considerations in things like engaging in text data mining. And in fact, we ran an institute last summer, and we recently published an open access ebook on a whole variety of law and policy topics related to text data mining. If you're interested in that, I can share the link later. And we also work a bit with researchers on data management alongside other groups at UC Berkeley, including the research data management team, especially when it relates to researchers thinking about how to share and publish their open data. And I'll talk a little bit about that more today. So copyright, contracts, open licensing, these are all important issues when we're thinking about research transparency and also reproducibility. So as you're preparing to write an article or use a data set, you'll need to consider two things as you collect materials for your digital scholarship and your projects. So the first thing is, if you're using content created by other people, you'll need to think about whether you need permission to include or share it online or distribute it to others. And then second, you need to consider your own rights as an author and think about how and whether you want to share your project in a way that encourages different types of reuse by other people. So let me show you what I mean in a little bit more concrete terms. So what we're allowed to do with other people's writings or data really affects our own ability to create new types of knowledge. So take this published article in a Springer Nature journal and the statement about data and code accompanying that article. So the article is copyrighted by the publisher, and the data and code availability statement in the journal article indicate that the authors put their underlying data in GitHub. And here's the corresponding GitHub page where the author's data can actually be found. So the authors might not have realized this, but if all they've done is deposit their data on GitHub, they haven't actually authorized anyone else to do much with that data. So if we look at GitHub's terms of service, we see that by putting their code or data on GitHub, anyone can use and reproduce the content, but only on GitHub. So in order to work with the data beyond GitHub, the researchers would have needed to apply a license to the content. And in this particular case, they didn't. But we'll see later on how you can and you should use open licensing if you actually want to share your data and have other people reuse it. So here's a different and maybe a little bit more clear example for contrast. So here, the authors of this paper have expressly licensed their article and their data under a Creative Commons attribution license. And this is good because it's now immediately clear and more obvious what other people are allowed to do with that data. And we'll talk a little bit more about Creative Commons licenses a bit later. So there's like two big things I want to hit on today, copyright and contracts. So let's talk a little bit about copyright law. And this is one of the key drivers regarding your digital scholarship and how you can leverage your own rights as an author. So what actually is copyright? So at its core, it's relatively simple. So the Constitution authorized Congress to create laws that promote progress and science and useful arts. And they mean science broadly here, and it includes all sorts of scientific, scholarly, and also creative endeavors. So basically, the drafters of the US Constitution, they wanted to develop an incentive for artists and authors to create things. And this is because we all, as a society, benefit if people can build on the discoveries that actually came before us. So Congress was authorized to give these creators some protection in the things that they made. But they also knew that they didn't want to give creators those rights indefinitely because protection that lasts forever would actually cut against reuse and building on the works that came before. So let's take a look at what these exclusive rights actually are. And the US Copyright Act defines 5. So what does this actually mean? Well, let's say I'm the author of this research paper on the right here. So copyright grants me the rights of reproduction, which means I can make copies of the article, the rights of preparing derivative works, which means I can adapt the article into another format. For instance, like make an audio version of it. I have the right to distribute it, which means I can hand out copies of the article at a conference. I have the right of public performance. Now, to be honest, it's kind of hard to perform a research article, but you can see how this would work, say, if you wrote a book and wanted to turn it into a play and charge admission for people to see that play. And then finally, public display. So I can put the article on display on my website or somewhere in public. And the copyright holder holds all of these rights exclusively, meaning that no one else can do any of those 5 things. But also notice what isn't protected in these 5 rights. Pointing someone to a lawfully distributed or displayed copy. So you're not invoking any of the exclusive rights by providing links to lawfully uploaded content. That's why you never have to worry that you're infringing copyright if what you're doing is linking to a lawfully posted or distributed version of a work. So we said that the carrot and stick balance with copyright is that these exclusive rights are granted only for a limited period of time in order to incentivize more creation. So around the world, the duration of copyright can vary, but in the United States, it typically lasts for the life of the author plus an additional 70 years. So within that term of protection, you need the copyright owner's permission to exercise any of those 5 rights that we just talked about. So just as a recap, copyright is meant to encourage both the creation and the use of works, and it gives authors exclusive rights for a limited period of time. Now, you might be thinking, okay, that limited period of time lasts for 70 years after the death of an author. That's really long, and you'd be right to think that. So the question is, how is anyone supposed to be able to use anything if these exclusive rights last for so long? Well, there are some crucial limitations on what copyright actually covers, and these are important, especially around some of the things that you're working on with data. So first, copyright only protects expression. It doesn't protect ideas. It doesn't protect facts. So you can't copyright a fact or a statistic or a method. Now, obviously, you should still be citing your sources if you're doing something like using a statistic, because you need to conform to the best practices for scholarship, but you don't need to actually ask permission to use it. So on the left here, for example, here's a simple graph, created by a researcher that graphs over time the count of unarmed victims of lethal force by the police. So there's nothing about this graph or the underlying data that is protected by copyright. Data are facts, and a line graph has no original expression. There's only so many ways that you can show this data as a function of time. So second, for a work to actually receive copyright protection, it must be authored, original, and fixed. So in terms of originality, there must be some minimal degree of creativity expressed. And we know that the courts have found that things like, a phone book, it doesn't receive copyright protection because there's no creativity in just listing numbers next to names. Second, the work has to be authored by a person. So works created by artificial intelligence don't get copyright protection. Works created by animals don't get copyright protection. And then finally, the original expression must be what's called fixed in a tangible medium. So it must be perceptible by a person or a computer. So with the photo on the right, there's copyright here because the photographer captured and recorded this image on film or say an SD card. So there's another category of work that isn't protected by copyright, and that's works that are in the public domain. So if something's in the public domain, you don't have to ask permission to use it. So first, on the left, US federal government works are in the public domain because they're not eligible for copyright protection. And the second category of works in the public domain are works that were protected by copyright, but now the copyright has expired. So on the example on the right, this is a book, History of Police in England, and it was published in 1905. We know now that it's in the public domain because the copyright has expired. So if something is protected by copyright, then the copyright owner has those exclusive rights for a long time. That means if we want to exercise one of those rights, like reproduce materials for a class or distribute them for use in our projects, we need to get the copyright holder's permission, except sometimes we don't. So sometimes we don't need the copyright owner's permission if our intended use falls under an exception, like fair use. So exceptions to copyright are like safety valves on these exclusive rights of the copyright owner. So let's dig into fair use a little bit more. So fair use is an exception that's built into the Copyright Act, and Congress included it specifically to encourage and protect criticism, comment, news reporting, and for our purposes, teaching, scholarship, and research. So making a fair use relies on taking an analysis of these four factors here. So the first factor is looking at the purpose and the character of the intended use. And we know that nonprofit educational uses are more likely to be considered fair uses than, say, commercial uses. The second factor addresses the nature of the copyrighted work. So a use is more likely to be fair if you're using a factual or a scholarly work rather than a more creative work, say like a painting or an artwork. Factor three looks at how much of the original they are using and how important the portion you're using is to the overall work itself. And then the final factor, factor four, looks at whether your use would supplant the market for the original. Now, keep in mind that the fair use exception is purposely broad and flexible. It's for that to promote academic freedom, expression, and education. So if you feel your use is not a fair use under this important limitation, you can always ask permission from the copyright holder. This might take some work. You need to figure out actually who holds the copyright, send them a request, and make sure that your request covers all the things you want to be able to do with the content. And also it's important to keep records for your files. So we just covered copyright. Let's dig a little bit into contracts. And there's two types of agreements under contract law that affect your digital project that you should know about. Database licenses and also website terms of use. So let's talk a little bit about databases. Let's say you use data sets that you downloaded from, say, a library database. So since we know a little bit about copyright now, we know that this is likely going to be a fair use if you work with the copyrighted data sets to provide new insights or new analysis. But there's one catch, which is that database agreements that libraries sign can affect researchers' ability to republish by restricting recirculation of the contents, even for uses that would otherwise be considered fair uses. And sometimes those agreements with certain types of resources would provide only for access and limited use of the materials. But the good news is that universities, and I'm speaking from the University of California, we sign database agreements that preserve fair use. So in many cases, if your project is just excerpting some content that you download from one of the databases that we license, you should be okay, because we've signed agreements saying that it's okay to make fair uses of that content. But if you're getting content from online sources that are outside the library's databases, then there's a greater chance that you're going to need to think about whether you can include portions in your project under that website's terms of use. Again, this is separate from copyright. So we already know that your use might be fair, but now there's a layer of contract on top of that via the website's terms of use. So here on the screen, we're looking at one of the terms of use from the Harry Ransom Center at UT Austin. And these terms indicate that users would be required to ask permission to reproduce images, even if doing so would constitute a fair use. And a lot of websites have these terms of use, and they're considered what are called browse wrap agreements, meaning that users consent to them simply by browsing the site, by looking at the site. But we do know that browse wrap agreements are not always enforceable by a court. So far, we've talked about the legal aspects of incorporating other people's scholarship into your digital scholarship. And we looked at copyright and we've looked at contracts. But how can you leverage copyright in ways that permit others to use and share the digital works that you're creating? So we can now turn to the step of choosing and applying a license to your works. And licensing matters because it's how you grant others the permission to use the copyrights associated with stuff that you create. So whether that's a research article or a data set or a piece of software that you've created. But before we go into this, let's think back and remind ourselves what copyright actually covers. So copyright protects original expression that's fixed in a tangible medium, and it doesn't protect ideas and it doesn't protect facts. So why does that actually matter? Well, first, the type of open license that you choose is relevant to whether the underlying content is protected by copyright in the first place. And then second, depending on the type of resource you're looking to publish, some licenses are preferred over others. So let's briefly talk about both of these issues. So for publishing research or other written content, it's recommended to use standardized open licenses, such as those offered by Creative Commons. So the Creative Commons licenses permit you to keep your copyright, but by using them, you grant broad permissions to others to reuse your research data in their own work. And these types of open licenses ensure that others who use and republish your creative works give you credit as the author. So the CC licenses are used in a variety of different types of content, from text, images, audio, video, and sometimes data. We'll get to that just in a moment. So the Creative Commons licenses are, there's 6 different flavors of them. There's also a copyright waiver that allows you to put your work directly into the public domain if you want to do that. And there are other types of open licenses that are available, including those that are provided by other stewards like Open Data Commons, the Open Source Initiative, Free Software Foundation. So speaking of data licensing and sharing, one thing that you don't want to do is add license restrictions where there shouldn't be restrictions. So say you've conducted a quantitative survey and the results are just simple factual data. Even though it might be attractive to attach a Creative Commons attribution license, we learned earlier that facts can't be copyrighted. They're in the public domain. So your data shouldn't be licensed under a Creative Commons attribution license. It'd be more appropriate to use the CC0 waiver. And that removes all ambiguity and really confirms to the world, that you've placed your data set into the public domain. And you shouldn't worry, because even if you won't be able to require attribution via the CC license, as we talked about earlier, the norms of academic scholarship can still go a long way to ensuring that you get the credit, because downstream users of the data set know that they should properly cite where they got it from. So if you're creating software and you want to release it under an open license, the Creative Commons licenses aren't specifically set up for this. There are already lots of other solutions specifically designed for and used for software, including the GPL, the MIT license, and some of the other licenses I mentioned just a minute ago. And there's actually a helpful website called choosealicense.com, and it can walk you through which open source software license is best suited for your needs. And just to sort of wrap it up now, so there are a few other things that you might want to keep in mind when choosing an open license for your project. These include provisions you've entered into under grants or funder agreements, and also some of the policies of particular content sharing platforms. So let's take a look at funding requirements. So maybe some of you have grants or other agreements that might dictate whether you need to release your scholarship under an open license. So for example, we know that recipients of grants from the Bill and Melinda Gates Foundation are required to publish their outputs under Creative Commons attribution, because that's what was agreed to in the grant agreement. And then the other thing to keep in mind is that sometimes repositories have policies around which types of licenses they'll allow content to be shared under. So for example, at UC Berkeley, we use Dryad, which is the data repository here. And that repository requires that all files shared there must be shared under the CC0 waiver. So the data there is in the public domain. So other repositories might permit more licensing options, but in this particular case, this is what Dryad has chosen. So if you're interested in learning more about some of these other literacies, like today we just talked about copyright and contracts, but we know the sort of sphere of issues that come up in digital scholarship is broader. And our office also works on education around privacy considerations and also ethical concerns as well. And we're happy to answer questions or if you want to reach out to us on those sort of issues as well. We have a website that has a lot of information. We have a YouTube channel with other workshops on some of these other issues as well. So thanks again, Alex, and everyone for the opportunity to present today. And we can have some questions now if there's time, or we can do it in the office hours